Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I want to talk with you briefly about a recent case that we filed because I think it illustrates a lot of what we talk about here, which involves debt buyer lawsuits. So companies like Midland, Portfolio, LVNV, those types of guys are suing us. Well, how do we beat those cases? And then what happens next? So we won. What about our credit reports? Do we dispute? Do we not dispute? Do we dispute directly to Midland or Portfolio or LVNV, or do we dispute to the credit bureaus? Equifax, Experian, and Trans Union. What do we do? And what happens when it stays on our report? How does that get handled? So this was a case where our client was sued by one of these debt buyers, and the client responded. So that's critical to respond however your court says to respond. In Alabama, we have to file an answer or motion to dismiss. That has to be filed with the clerk's office. Because if you don't do that, you lose by default judgment. So our client responds. Well, then you get a trial date. Well, then you've got to show up to trial. Or if you have a lawyer, your lawyer shows up. So our client shows up, and the debt buyer is unable or unwilling, frankly, it doesn't matter, is unable or unwilling to prove it owns the debt. So guess what? It loses because we don't have any connection with Midland or Portfolio or LVNV or whoever it is. We don't have any connection with them. Now, they say they bought a debt, but they have to prove they bought that debt. Otherwise, that'd be like me suing you saying, you need to make your mortgage payment, your rent payment, your car payment to me. You're like, who in the world are you? Okay? So they've got to prove they own that debt if they want to get a judgment and get money. Well, they didn't do that. So they lose. So what does that mean? Well, let's think about it for a second. So I get sued by LVNV, Portfolio, Jefferson Capital, Persolve Legal, Midland, whoever it is. They sue me and they lose. Do I owe them any money? No. I've got a court order that says I won. So whatever they've accused me of, I'm not guilty of it. Well, what do they accuse me of? They accuse me of owing them $1,000 or $5,000 or $10,000 or $30,000, whatever it is. Well, I'm not guilty of that. I do not owe them that money. So what does that mean for calling me? Well, they better not be calling me. What does it mean for writing me a collection letter saying, John, you owe this money? No, they better not be doing that because I've got a judge saying I do not owe that money. And I'll say this, not all of these guys, okay, but most of the major debt buyers. So kind of the big ones are Midland, Portfolio, LVNV, okay? There's other ones. Generally, they get this part right. They won't be calling you or writing you letters on that debt that they lost. Now, sometimes they do, and they need to be hammered for that. But the real issue comes up on your credit reporting. So here you are. They are reporting on your credit report, and then they sue you. You answer, you go to trial, you win. Well, they're reporting all this time. Well, what about after you win? Should they be reporting? So here's the question. Do you owe LVNV $5,000? Do you owe Portfolio $7,000 or Midland $3,000? After the judge says you win? Obviously not. You don't owe that money. So what are they doing reporting after you won your case? And let's assume there's no appeal. I mean, that case is done. It's over. It's final. It's finished. And they still report that you owe this money. Well, that's a violation, in my view, of the FDCPA, the Fair Debt Collection Practices Act. And that comes, there's other places, but specifically Section 1692E8 says, don't do any false credit reporting, Mr. Debt Collector. Well, if I've got an order saying I won my case, and then after that, they continue to report false credit report. Frankly, the credit reporting before they sued me, after they sued me, the day before trial, the day of trial, all of that's false credit reporting as well. But clearly, after I won my case and they're still reporting on me, that's really, really bad. Okay. So I could sue the debt buyer under the FDCPA. Well, how do I get it off my credit reports though? Does Equifax, Experian, and Trans Union, Innovis, any of these guys have any responsibility? Well, sure, they do. Okay. Now, generally, not always, But generally in this type of situation, we need to notify the credit bureaus. Okay? So we do that through a dispute. And that can be done online, by telephone, by mail. If you do it online, I've talked about this in other videos, make sure you get a screen recorder for your screen, record it. So if you're doing it on, I don't know where my cell phone is, but like your iPhone, I'm sure with Android, you can do a screen record. If you're on your computer and you don't have specific software, you should be able to use Zoom, just like do a Zoom with yourself and share your screen. You've got Google Chrome up or Safari or whatever. Log into Equifax and record the Zoom meeting. Okay, so that's one simple way to do it. But for most people, we recommend do it by certified mail. So you can prove these guys got it, okay? Because the bureaus really are bad now about they get your letter and they won't do anything. And then they go, oh, well, we really need like 9 months to investigate because, there's this thing called COVID. Now, of course, they're reporting on you every month. No problem there, but only on investigation do they go, oh, wow, we just discovered there's this thing called COVID. We can't do anything, but we'll still make all of our money on you. Okay, so do it by certified mail so you can prove when they received it. And so you dispute it. Well, what do you say in your dispute? Well, there's no magic language. You just say, look, there's this Midland account, LVNV, portfolio, whoever it is. They're on my credit report. They sued me. I won. Give them some information. Here's the case number. They can call the court, include a copy of the lawsuit or the order where you won. Okay? You can give them that information. Now, half the time they go, well, we presume this is fraudulent. You forged these things. We say, well, did you call the court to verify? Well, no, we're not going to do that. We only have 4 minutes to investigate. We're not taking that amount of time to call somebody and check on. We're just going to assume it's all fraudulent. Well, hey, buddy, that's your problem to assume that. But anyway, so you reach out to the credit bureaus. Well, what's their obligation? Their obligations under Section 1681I. Think of I for investigation. You're asking them to investigate. So what does the credit bureau have to do? Here's the credit bureau. They have to notify the furnisher. So the furnisher would be that debt buyer, LVNV, Midland, portfolio, whoever it is. Here's the credit bureau. Here's the furnisher. And the credit bureau has 5 business days to notify them and say, hey, this consumer has disputed this. What do you say about it? Now, if the credit bureau does not do that and they do not delete the account, then they got a big problem. Now, what I'm talking about when you say, hey, look, I got sued and I won, they really don't even have to go to the furnisher, the debt buyer. It's pretty obvious. It's absolutely obvious, okay? They should just delete it. But if they are going to notify the furnisher, now the furnisher has liability under the Fair Credit Reporting Act. So remember, the credit bureau is under Section 1681I, I for investigation. The furnisher, the debt buyer, their obligation is 1681S2B, not S2A. There's no ability to sue for that, but under S2B. Now, their obligation is to do a proper investigation, the same as the credit bureau. So the credit bureau and the furnisher both have to do an investigation. Well, if we told the credit bureau, I got sued and I won, that's pretty easy. How about the furnisher? Well, they know they sued you. They know that they lost and you won. I mean, how easy could this possibly? I mean, there's no way to make it easier for the furnisher, okay, the debt buyer. They know they sued. They know that they lost. They know they didn't appeal. They know they have to take it off your credit report. And when they don't, they violate that Section 1681 S2B. When the credit bureau refuses to delete that account after you won, they have violated Section 1681I. Well, there's another section that generally we sue under, and that is Section 1681E and then parentheses B. And that's for the credit bureaus. That's this part of the law, the Fair Credit Reporting Act, that says you must have reasonable procedures to assure maximum possible accuracy. Now, that's even if you don't make a dispute. But, we can be generous with the credit bureaus and say, before we told you that Midland LVNV portfolio sued us and we won, maybe you didn't know. But after I told you, after I started the investigation, I made the dispute, you guys investigate, and then afterwards you continue to report this, not only have you violated 1681I, but 1681 S2B. Okay? And I'm sorry, that would be the debt buyer doing that. For the credit bureau, it'd also be section 1681EB. So there's 3 provisions, 2 for the credit bureaus, 1681I, 1681EB, and then 1 for the furnisher, 1681S2B. So put all that together. What does that mean? Well, you get sued, you respond, you win your case, you dispute it with the credit bureaus, you let them know what happened, and they don't fix it, then you're looking at suing the credit bureaus under Fair Credit Reporting Act. You're looking at suing the debt buyer under the FDCPA, Fair Debt Collection Practices Act, and the Fair Credit Reporting Act, and then usually state law. So we'll sue for malicious prosecution, abuse of process, some other state law claims. And so we may have a lawsuit where there is the debt buyer, and sometimes they have multiple companies, kind of like Midland Credit, Midland Funding, and they really operate interchangeable. You'll see one on maybe your Equifax report and a different one on your Experian. They're one and the same. So we always sue those 2 guys together. And then you sue the 3 credit bureaus, Equifax, Experian, and Trans Union. Well, what are you asking for in damage? When we do one of these suits, what are we asking for? We're asking for compensatory or actual damages. Usually 2 parts of that. One is going to be the economic part. So, hey, you damaged my credit score by not fixing this. In other words, had you removed this, my credit score would have gone up. My credit report would have looked better, even outside the score. Just getting rid of this negative account, right? This Midland Portfolio LVMV account. And so that has damage. So maybe I lost a job. Maybe I lost refinancing. Maybe I lost a home loan. Whatever it is, those are economic damages. But then there's the emotional distress damages of, I don't have a choice for Equifax, Experian, Trans Union to report on me. I don't have a choice on whether Midland or Portfolio or LVMV reports on me. They don't ask my permission. But here's what I do have. I know that they can only report accurately. Well, what happens when they violate that? Well, I can sue them for violating that, but definitely when I dispute it and say, guys, what are you doing? Hey, Equifax, Experian, Trans Union, get this bogus account off of my credit report. And then they notify Midland or Portfolio or LVMV, and those guys do a terrible investigation. They don't get it off. Well, then that's incredibly upsetting to me because I don't have any control over this. And think about what's going on here. The credit bureau is sitting there going, well, this debt buyer sued this consumer, and a judge said no money is owed. We don't care what a judge says. We think we're above the judges because we're the credit bureaus. And same thing for the debt buyers. They think that, well, they're like, well, maybe that judge ruled in your favor, but you still owe the debt. No, you don't. Okay? And so it's so arrogant for them to do this and so sort of condescending for them to look down on you and say, we don't care about you. We're keeping this on your credit report and there's nothing you can do about it. That's what they believe. Here's the sad thing. They're kind of right because most people won't do anything. But hopefully if you're I don't know how long this video has been going on, 10 minutes or so. If you're still watching this, hopefully you're not the type of person that would say, well, I got sued and I won and I disputed and they won't take it off. I guess I'm just going to give up. You wouldn't have made it this far in the video. So for those of us who will not give up, then we hammer these guys and think about what will a jury think? And they're sitting there listening to this going, okay, here's Equifax, Experian, Trans Union, this debt buyer. And a judge ruled in your favor, and they're like, we don't care. And then when they get caught, when they get sued, they go, well, it's too complicated for us to figure out. And we've had these companies that sue us, and then we beat them. This literally will be their excuse. They'll say, John, you don't understand. We file thousands and thousands and thousands of lawsuits a year in Alabama. Across the nation, we might file 5,000, 10,000 lawsuits a week. We can't possibly keep up with all. You can't really expect us to keep up with that. How should we be expected to know whether we win or lose? My goodness, we got so many of these. And we're like, are you seriously going to make that argument in front of a federal judge, in front of a jury, that because you file so many cases, you shouldn't have to keep up? I mean, does that work with criminals? Where Judge, I mean, I have robbed so many banks. I mean, you can't expect me to remember, like, did I rob this bank or that bank? Like, I don't know. It's like, and I do so many, like, why should I be punished for that? That's what the credit bureaus and these debt buyers say. And so we have to educate them on this, that it does matter. And the jury, when that jury speaks the truth, when that jury gives its verdict, then it educates. Okay? And that's a message that's received by Equifax, Experian, and Trans Union and these debt buyers. And that verdict needs to be so big to compensate you that they go, wow, when we fail to do a reasonable investigation, we ignore what a judge says, there's going to be full justice for this person in Birmingham or Huntsville or Mobile or wherever they are in Alabama. The jury will award full and fair compensatory or actual damages. Well, then we also get statutory damages. And we also ask for punitive damages. How much money will it take to punish Equifax, Experian, Trans Union, these companies that may not even respond to your dispute, that they give you just form letters, okay? And they go, we don't care what a judge says. We're keeping this on your credit report because all we will listen to is that debt buyer because that's our customer. When they do that, how big does that punitive damage award have to be to do two things. One, to punish. I mean, you violate the law intentionally, you get punished for that. Number two, to deter, to discourage them, to try to get through their brains that maybe this isn't such a good idea, to just violate the law flagrantly, to say, we don't care about what this small claims judge says, or we don't care about this consumer in Alabama. It doesn't matter to us. We're going to put whatever we want on your credit report. We have to make it so that award is big enough that when the executives are sitting around at Equifax, Experian, Trans Union, Midland Portfolio, LVMV, whoever it is, and they go, I wonder if we should pay attention and actually follow the law. Somebody goes, it's a whole lot cheaper to just not follow the law. We'll get some people in India or Colombia or somewhere and we'll pay them nothing to do these investigations. And they all laugh when they say that. And somebody goes, but remember, we got hit with that big verdict for doing this. Oh, yeah. And it's this verdict and that verdict and another verdict. And eventually it gets to a point where they go, it's more expensive to violate the law than to just follow it. Maybe we should actually do reasonable investigation. There's a novel thought for you. Okay. So that's the purpose of the punitive damage award. And then they can be required to pay attorney's fees. And so that I just want to give you an idea, and I don't mind getting into the specifics of the individual suits we file because it's all public record. But I just want you to see kind of the outline. When you're sued by a debt buyer, the reason that we're saying answer that case, because you can win. The reason we harp on understanding the rules of evidence and the importance of the purchase agreement, all the videos we talk about, how to testify in court, mistakes to avoid, all of that is so that you can have the best possible chance to win. Because when you win, it must come off your credit report. And normally the way you do that is you dispute through the credit bureaus. And if they take it off, great. Hey, they did their job. That's fantastic, okay? But if they won't get it off, then you look at hammering these guys. These are big, big lawsuits. Now, the credit bureaus will come to us and go, well, John, seems like you're kind of technical. I mean, what's the big deal? We kept this bogus account on there after judge said you don't owe it. I mean, what? We'll pay you a couple $1,000, we'll pay you $10,000. I mean, there's nothing to that. Oh, these are big cases. And when the credit bureau lawyers don't recognize that, that's okay. Because we're just marching along to trial. And if a jury tells us it's not a big deal, okay, heck, the jury's spoken. But if a jury speaks and says it is a big deal, well, that's pretty fun. So I hope that you found this helpful, and hopefully it didn't go too long. And I appreciate you guys, tuning in, watching our videos, commenting. And if there's anything we can do to help you, if you have just a general question, you can put it on the comments. if you have a specific, sort of private question, just reach out to us at alabamaconsumer.com and we'll be glad to chat with you. Okay, have a good one. Bye-bye.